In this class we want to talk about the effectiveness of dispute procedures. Organizations use a range of dispute resolution procedures to deal with workplace conflict. They don't just have one, they have many different ways in which to approach a problem and try to resolve it. Organizations will use dispute resolution methods that are appropriate to resolving conflict in the workplace. They always try to find the most appropriate solution given the nature of the problem. If the problem is small, it may be dealt with locally. It may be dealt with between line managers and managers and workers and so on. If it's a large problem, a big problem, perhaps one involving working conditions overall or involving remuneration, involving pay and salary and so on, this may be a bigger issue and will have to be resolved using different techniques. The method of dispute resolution are effective, however they also have limitations. Generally speaking, we can say that dispute resolution techniques are effective because companies exist, companies continue over time. So we know that the companies have issues with the workers and the workers have issues with the companies, and we know there is the basis for dispute there, but we know also that the companies continue to produce and continue to exist, so the solutions must have been found. But the various methods that are at the disposal of both the trade unions on the one hand and management on the other, the various techniques, they have limitations. There isn't a panacea, there isn't one overarching solution to all problems. So it critically depends on the nature of the company, the nature of the business, the type of work done, the scale of the problem. It depends on many factors. Here we want to talk about alternative dispute resolution. Alternative dispute resolution means looking at different ways in which problems can be solved. Some of them are quite innovative in many respects in the context of industrial negotiations, employment negotiations. And each of them, as I said, will have advantages and disadvantages. So, alternative dispute resolution can be a cost-effective approach. Some services are free. So, in other words, it's looking to outside agencies, it's looking to government agencies or perhaps agencies which in the past have helped in bringing about solutions. So some of these services are free, and that's useful. It's useful for both the unions and the management. But more importantly, they may be effective. But they're not suitable for all types of claims. Sometimes the best solutions are the ones which are generated internally, in face-to-face negotiations internally within the business. The workers on the one side, the management on the other, trying to resolve the problem together. That might be the best solution. But if that fails, then they could use alternative dispute resolution techniques involving outside agencies or outside people, outside negotiators, outside people who have experience of bringing together the two sides in employment. Generally speaking, they offer a range of services to handle different cases. The different services could be meeting one side, getting their point of view, then meeting the other side, getting their point of view, then trying to bring up a proposal which will be halfway between the two and trying to get conciliation and agreement between the parties, or it may be they simply bring the two parties together and in a face-to-face situation and then try to act as chairperson to the meeting, trying to resolve the issue. Arbitration, that's when both sides agree that whatever the middle person who's been brought in from outside, the middle person agrees should be the solution. If both sides agree to accept that, then that may become the preferred method of resolving the problem. But finding a suitable arbitration, a suitable go-between, which will not adversely affect one of them badly, will not impose severe costs on one side, or make the unions lose face with their members, or impose extra costs on the management. Trying to find that middle ground, that solution, can be very costly and very time consuming. Alternative dispute resolutions can be very quick and very simple for a small organisation disputes. Simply reverting it off to someone else, to perhaps a respected person within the field, or even a legal person, or referring it off to someone who is neutral. That might be the best way of getting the solution. Of course, not all cases resolved are in the favour of both parties. Sometimes the solutions that are brought up may inconvenience both sides. Neither side get what they want. They have to compromise. So therefore, there are no winners. Both sides have had to give ground. Cases are resolved within weeks or days. Generally speaking, once alternative dispute resolution techniques are sought, once outside agencies are involved, or once experts are involved from the outside in disputes, generally speaking, the solution is brought about fairly quickly. Once the cases are stated, then a decision is made. It provides an informal approach, and it may not be favoured by large organisations. Large organisations tend to do their own negotiations and have their own expertise, have their own people in place for the negotiations, and likewise the trade unions know this, and they also have expertise and a great deal of skill in handling that situation. So for large organisations, they don't seem to use outside agencies so much if they can help it. ADR is a growing approach, offering high levels of success. Having said that, the idea of having someone who is independent, or some organisation who is independent, having some way of dealing with the dispute independently, seems to be becoming increasingly popular. It does not favour solicitors, as the service impacts financial gains. The reason here is that sometimes the person involved in bringing about the solution may have a vested interest in protracting the negotiations. For example, unscrupulous solicitors or lawyers may string out the negotiations so that their fees become significantly more. That's just a possibility. It's not to say that it happens on any great scale. And by and large, solicitors and lawyers are trusted individuals who are professional and will do a good job and will be brought in for the purpose of this, and will be trusted by both sides to bring about a solution. It's just that within every apple cart there may be some apples which are bad, and that is a problem. When we look at negotiations and mediation, negotiations being trying to resolve the problems by finding bit by bit solutions and putting up alternative packages and alternative solutions, and mediation, trying to go in between and find middle solutions. Well, there are advantages and disadvantages to this also. First of all, the advantages. Well, it's a very informal approach to conflict resolution, and of course therefore it's less stressful. It's negotiations and mediation and trying to find a way forward, trying to negotiate what is acceptable to both sides. Generally speaking, it doesn't offer legal precedence. It doesn't. It's not based on the past. Generally speaking, this type of negotiation and mediation, they are specific to the problem in front of them at the moment. They may refer back to cases in the past and say this is what you agreed in the past, but that may be easily dismissed by saying the world has moved on, the market has moved on, the company has moved on, or the trade unions could say, well, our employees and our membership are no longer naive and will not accept that anymore. Easily dismissed situations. So there are advantages to having informal approaches, but there are also very little to rely on. They seem to negotiate on the issue in front of them, not look to past and look to what happened in resolving issues in the past. The whole process is internal and of course maintains confidentiality as such, or should do. It would be wrong to leak the information coming out as the negotiations continue, because that can influence pressure from the outside. When the whole package hasn't been agreed, it may upset the negotiations if people from the outside who are not immediately involved in the negotiations are objecting or making points or asking that certain conditions be laid down as well. In fact, what should happen is the whole package should be worked out and then presented. Mediation must be based on good faith. Not all parties will comply. So it is a problem, and the companies and the trade unions must enter into this process with the intention of getting a solution. There must be a real desire on their parts to resolve the issue. It can promote positive communications between the parties. It can enable each of them to see each other and to talk to each other and to realize each of them have constraints and problems to address, and there's greater understanding perhaps as a consequence of the whole process of meeting and negotiating. Of course, power imbalances can impact on authority over bargaining. In a sense, what happens is that one side may be stronger, in a stronger position than the other, and therefore the negotiations will be swayed in one direction. If both parties have equal power and both parties can inflict pain on the other, significant pain on the other, then they will try hard to find a solution that will accommodate both of their needs and their requirements. On the one hand, the management, of course, must find a solution which is acceptable to the shareholders and to the owners and to the stakeholders of the business, indeed, to the suppliers of the raw materials and to the marketing section and the outlets and the supply chain. They must find solutions which will accommodate all of those various demands. The trade unions, for their part, must meet the requirements of their members. It's the members who have elected them and put them in place to do the negotiations, and they must be able to convince the membership that the final solution is correct and appropriate. Both parties are in control of the decisions and agreements. Either side may break it. Either side may leave the negotiations at any time. There's no force being used to force them into the negotiations. So they have control. Each side has control. Each side may seek adjournment or seek more advice or go back to the membership and resume the negotiations at a later date. Both parties have to take each other into account, but they are, in a sense, in charge of the negotiations as well. They may bring it to an end at any moment. The process may not have the protection of legal rights for both parties. So both parties must beware or be wary of agreeing to something which perhaps breaks a contract or breaks a previous agreement. So there may be some issues that they need to take into account, and then they have to work around those, which again makes the negotiations much more complicated. Increased satisfaction as both parties collaborate to reach a solution. Both parties should at the end be happy with the solution. They both should be in a win-win situation. They should feel that both sides have won. Both sides got what they wanted. They've agreed to a solution and their requirements have been met. There's obviously, it involves cooperation, and it obviously involves compromise. But the solution should be acceptable to both parties. The disadvantage of this process is that the mediators, the people who are brought in from the outside to try and facilitate the negotiations, may not be sufficiently trained to deal with conflict resolution. They may have inexperience, or they may not be familiar with a particular product or industry, and that may limit their contribution and their effectiveness. The process is risk-free if no solution is evident. Other options can be researched. So if a solution doesn't come about through this type of situation, then they can look to other ways of doing it, perhaps taking advice from experts, or indeed it could lead in the end, unfortunately, to strikes or to quite severe industrial action on the part of the unions. Or it could even mean that the management lock out the workers because they're so upset with the agreements or the lack of progress or the damages that has been done to the business. But generally speaking, it's risk-free. They can end the negotiations at any time and look for other ways of trying to resolve it, preferably not by the extreme measures that I've just mentioned. The disadvantage, well, it can be used as delaying tactics by some parties. Sometimes the parties may want to string out the negotiations so that there's no obvious solution, and this can frustrate the negotiations, and in the end the other party will accept something less just to get the negotiations completed, rather than having the negotiations drag on and on. Both parties have control over who they choose as mediators. The people who are brought in from the outside to facilitate the negotiations, these will have to be agreed by both parties. If one of the parties objects, then that person should not be forced on that party. Both parties must agree, both the management and the unions must agree to any mediator that's appointed. And of course, the agreements are not legally binding. That might be a bad thing, or it might be a good thing. It depends on what the intention is, and whether they wish to make it legally binding between them, if they wish to have some sort of contractual arrangement, or whether they just simply say, we will work on this basis and we'll come back later and renegotiate if there are any further issues. The process is voluntary and free. Nobody forces the management or the unions to go down this road. It's a voluntary and free process. There are high levels of flexibility since negotiations are tailored to the needs of the parties. So, in a sense, the negotiation starts with a blank sheet of paper. In a proverbial sense, a blank sheet of paper, and they start to fill out what are the constraints, what are the issues, what are the red lines, what will the unions not accept, what will the management not accept, and from this the negotiations can start. Legal standards and policies are complied in facilitating the resolution process. So legal standards and policies must be recognised as a part of the process. Clearly, the final agreement must be legal, it must be fair, it must not exploit anyone, it must deal honestly and openly with the parties. There must be no hidden agenda or ulterior motive in the negotiations. Alternative courses of action that may take place should be mentioned, ideally, so there's openness and honesty right throughout the process. Arbitration. Well, the advantages and disadvantages of arbitration. Well, parties are free to choose an arbiter. And of course, success is dependent on the ability of the arbiter. Now, an arbiter is someone who has the confidence of both sides, who will listen to the case from both sides and will decide what is the best solution. Ideally, I suppose, in the middle between the two of them. But the problem with this is that leads to both sides making extreme claims to start. So that by getting a middle solution, they're getting more than they would have got had they been honest at the start. So by making the gap between each other very wide, the management conceding very little and the unions demanding a lot to start with, that makes arbitration difficult, because a middle course then will mean that the unions will get more than they really needed or initially wanted, and management will, in a sense, have to meet this, or it could work the other way around. Management will get more and the unions will get less. In either case, the interest is on both parties to make their positions extreme, so that they appear to be negotiating, they appear to be giving ground, but in fact they're only giving ground and appearing to move in the negotiations because they made their positions so extreme in the first place. So that could be a drawback of arbitration. It's important that the process maintains confidentiality, and it's important that nothing is leaked, because if it does, it could influence the negotiations, it could influence what is being proposed, and perhaps, say, the unions may object, or people not directly involved in negotiations may object, the membership may object. Likewise, on the management side, some of the stakeholders, the shareholders, or whoever may object. So it's important that it's kept secretive until the end. The decision should be binding. Once both parties agree to a binding solution, then once the solution has been found, it should be bound by. That's what they agreed to. So once the solution is agreed, once the arbiter has found what he or she believes is an equitable solution, then both parties must agree to that. That's what the arbiter was there for, to find a solution and, in a sense, impose the solution. And both of them agreed to that, so they should stick with it. It's a formal process, and parties must follow a code of conduct. They must present evidence of their case to the arbiter. They must argue as to why it's a fair and reasonable case, and make the arbiter understand the situation, understand the pressures, and understand the constraints, and at the same time argue for what they want. Of course, confidentiality is another issue. Well, as I mentioned earlier, it may not be suitable for some cases. Sometimes it's necessary, perhaps, for the trade unions to go back to their members and tell them what has been offered or what the arbiter is thinking, and ask to see if it is acceptable. It could be that the management can't accept some decision of the arbiter because it will affect their position in the market and perhaps give their competitors an advantage. So sometimes confidentiality may not suit the negotiations. The final decision is binding, or should be binding, on all the parties. They agreed to this at the start. They agreed that the decision of the arbiter would be accepted, and therefore at the end they should be bound by that. It's less expensive than going to court. Going to court is very expensive. It involves the time of the court, the legal personnel, legal representation. It's a very costly exercise. This is much cheaper and probably much more efficient. A quicker solution may be found. With litigation, this is the one of going to court using the law. Formal procedures, parties can not abuse the process. It's a very formal procedure. If they're going to law, then they must follow the requirements of the legal system. It's very time consuming and it's very expensive. So no quick solutions, and whatever solutions do come out, these are expensive and could also be difficult to implement. All the parties involved in dispute must attend the tribunal. Typically, litigation is through tribunals, through a small number of people, legal people with authority, who listen to the case on both sides. Sometimes it doesn't take place in a courthouse. It may take place in some offices, but it is a legal process. They listen to the case on both sides, and then they will decide what is right and what is wrong, and give a judgment, and both parties are bound by that. The parties are not involved in the decision-making process. The parties simply state the case and clarify any issues, but they're not really involved in the decision-making process. They're not in a position of negotiations. All the parties are safeguarded during the tribunal process. They are safeguarded against undue influence. They're safeguarded against the opposing party making threats, or the opposing party attempting to negotiate or changing their case. So they are safeguarded in the sense that they can just make their case as they see it, and if the case is felt to be reasonable and fair, then they should have a judgment in their favour. The information may not be kept confidential. We live in a relatively open society, and therefore the information that goes before tribunals may be released into the public domain, and therefore the effectiveness of the cases presented will also be open to scrutiny. So that, for example, the trade union's case will be known by the membership, who will then judge whether the trade union made a good case or not. The final outcome from the process is legally binding. When the tribunal has made a decision, that is the legal position, and both parties must agree to it. That is the law. There are appeals that may be lodged looking for some other factors to be taken into account, or an appeal to say that the judgment was unfair because certain issues were not fully considered or fully taken into account. That may happen, but again, it's a long process. It's an expensive process, and the costs and disadvantages of lodging appeals has to be measured against the likely advantages of so doing. So what we've looked at here are different approaches to dispute procedures, and looking at the effectiveness of these and trying to classify them on their positives and negatives, and trying to get a feel for the different ways in which disputes could be dealt with. One is to simply negotiate face to face, try and find a solution. One is to have an arbiter who simply decides what the solution is and both sides agree to it and accept it. Or they may go to law and try and find a solution through the legal system. Clearly there are financial and time constraints involved in the different approaches that are encountered, and there are also issues as to whether which one is the most appropriate, depending on the size of the problem, the number of workers involved, the size of the organization, the importance of the solution, and many factors need to be taken into account. But that's all we're going to deal with here, so I'd ask you to go back over these notes and make your own notes. Try to get an understanding for the different approaches to how to resolve disputes, and just make your own notes and pad them out perhaps from some additional reading. But that's all I'm going to do here, so let's leave it at that and say thank you for watching.